Good afternoon, everyone, and welcome to another session of credit transactions. We have already discussed loans and deposits, and we shall now discuss guarantee and suretyship. So when we talk about the contract of guarantee, by guarantee, under 2047 of the Civil Code, a person called the guarantor binds himself to the creditor to fulfill the obligation of the principal debtor in case the latter should fail to do so. So when we study this article, we have to remember that we're talking about guarantee proper, okay? When we say guarantee, this is actually an accessory contract. It is accessory because it is dependent for its existence upon the principal obligation guaranteed by it. We already mentioned earlier that by guarantee, a person called the guarantor binds himself to the creditor to fulfill the obligation of the principal debtor in case the latter should fail to do so. Now, you must remember that guarantee could be a personal guarantee or a real guarantee. When we talk about personal guarantee, ladies and gentlemen, this pertains to either guarantee proper and suretyship. All right? This would, when we talk about personal guarantee, this would only involve the personal commitment of the person to answer the obligation if the principal debtor defaults. Okay? In other words, walay specific property that is subjected to the claims of the creditor. Okay, iyaharag yung personal commitment nga yes, in case the principal debtor defaults, I will answer the principal debtor's obligation. Alright? Unlike in real guarantee, unsa maning mga real guarantee, ang example ani kaning pledge, mortgage, anti-crisis, okay? In real guarantee, there's a specific property or properties that is or are subjected to the claims of the creditor. Lahi siya, it's so different from personal guarantee because in personal guarantee, walay specific property that is involved. It's only the personal commitment of the guarantor or the surety. But in real guarantee, there's a specific property, say in pledge. To secure the obligation, you give your ring. Okay? In mortgage, to secure the obligation, you either mortgage a car or kanang mga equipment. In a real estate mortgage, the same is true. You mortgage a land or a house. In anti-crisis, there's a particular, let's say, tree nga imuhang igarantiya in order to secure the principal obligation. This basically are the distinctions between the real guarantee and that of personal guarantee. So, in personal guarantee, remember nga kung walay specific property, onya, the document says guarantee, you can always presume nga this is guarantee proper. Okay? Di na siya surety. Kung ang document would say this is guarantee and this is a personal guarantee and there's no specific property, the presumption is that this is guarantee proper as opposed to suretyship. Now, when we talk about suretyship, this is actually a kind of guarantee, personal guarantee, wherein the guarantor binds himself solidarily with the principal debtor. Okay? Ang tawag ani niya is surety. Okay? And when we talk about this kind of contract, we call this contract a contract of suretyship. Okay? You need to see the distinction ha kung mayong kagkontrata, the contract is called suretyship when we talk about the person who binds himself solidarily with the principal debtor, that person is called a surety. All right? Now, because the surety bound himself solidarily with the principal debtor, what is the effect? Did he now become a solidary co-debtor? The answer is no. There are a lot of reasons wherein we cannot consider a surety to be of the same footing as that of a solidary co-debtor. Firstly is with respect to the liability. When we talk about the liability of the solidary co-debtor, ang iyang liability is direct and primary with that of the principal debtor, okay? Upon default, he can be held liable immediately. But in surety, dapat mag-default si principal debtor before the surety can be held liable because this is merely an accessory undertaking. Alright? Another distinction is when a surety pays, ordinarily, he will be subrogated in the rights of the debtor. Ordinarily, kay ang surety, naman siya interest sa fulfillment sa obligation. Okay? So, upon payment, si surety will be subrogated to the rights of the creditor. Except, of course, in case when the contract is entered into without the knowledge or against the will of the principal debtor. So, in suretyship, you have to note that ang necessary parties lang ani are the surety and the creditor. Okay? Pero you may say, this is unusual, attorney, because usually ang mangita gani og surety ang principal debtor man, diba? Yes, this is unusual, but this is possible. Na may uban nga mo willingly lang gyud og volunteer nga ako na lay surety anang principal debtor, diba? And if the said contract is entered into by the surety and the creditor without the knowledge or consent or against the will of the principal debtor, the surety cannot be subrogated to the rights of the creditor. Okay? In solidary obligation, on one hand, there's no subrogation. Alright? The solidary co-debtor can only demand the reimbursement from the co-debtors only with respect to their respective shares. Alright? Ang last difference, ani, is when we talk about the agreement between the principal debtor and the creditor for the extension of the fulfillment of the obligation. If this particular instance is entered into without the knowledge of the surety, automatic release na si surety from the obligation. Extinguish na iyong obligation as the surety. But in solidary obligation, dili ma-extinguish because this is actually favorable to the solidary co-debtor if there be an extension of the fulfillment of the obligation. Alright? Now, let's talk about some of the principles nga commonly mugawas sa exams, sa bar, okay? Kaning atong gitawag og benefit of excusation or the benefit of exhaustion. Under Article 2058, the guarantor cannot be compelled to pay the creditor unless the latter has exhausted all the property of the debtor and has resorted to all the legal remedies against the debtor. Article 2059 provides that the excussion shall not take place, however, if the guarantor has expressly renounced it, iyang gi-renounce. Ikaduha, if he has bound himself solidarily with the debtor, in this case, he becomes a surety. In case of insolvency of the debtor, when he has absconded or cannot be sued within the Philippines unless he has left a manager or representative. If it may be presumed that an execution on the property of the principal debtor would not result in the satisfaction of the obligation. Further, Article 2060 provides that in order that the guarantor may make use of the benefit of excusation, he must set it up against the creditor upon the latter's demand for payment from him and point out to the creditor available property of the debtor within Philippine territory sufficient to cover the amount of the debt. Also, ato lang ning diretsuon og basang ubang articles before I discuss it further. Article 2065, should there be several guarantors of only one debtor and for the same debt, the obligation to answer for the same is divided among all. The creditor cannot claim from the guarantors except shares which they are respectively bound to pay unless solidarity has been expressly stipulated. And further, the benefit of division against guarantor ceases in the same cases and for the same reasons as the benefit of excusation against the principal debtor. Okay, benefit of excusation. As a rule, a guarantor has a right of excusation. Alright? Meaning, before siya malliable, kailangan i-exhaust sa ang property ni principal debtor. Okay? Pero si guarantor has the obligation to point to the creditor the properties of the principal debtor. So kung wa siya ma-point, liable na dayon si guarantor in this case. So example, si principal debtor owes the creditor 1 million. Naa siya'y guarantor, okay? Si G. Si G, before siya ma-liable, kailangan i-exhaust sa ni creditor ang tanang property ni principal debtor. So, before siya maningil ngadto kang G, kailangan hutdon sa tanan ni creditor ang possible properties nga available ni principal debtor. Kung maningil man gani si creditor diretsyo ni guarantor, kailangan si guarantor ang iyang obligation is to point to the creditor. Kailangan siya mingon, creditor na pa'y property si principal debtor, kanang naa sa liluan, kanang naa sa konsolasyon. Kailangan niyang i-point, okay? Otherwise, kung wa siya mo point, meaning exhausted na tanang properties ni principal debtor, so in this case, si guarantor will be held liable na. Alright? Except, of course, kung si guarantor in this case bound himself solidarily. So, kung he actually bound himself solidarily, it becomes a suretyship. So, there's no longer a benefit of excusation as discussed earlier sa 2059. Okay? Mga exceptions to the principle of the benefit of excusation. Now, on to the benefit of division, katong 2065. In contracts of guarantee, there may be co-guarantors. Okay? Kaning mga co-guarantors are the guarantors securing the fulfillment of the same obligation. In other words, usara ka obligation pero daghan kaayong guarantors. Okay? Let's say, kung naay obligation nga say 200,000 pesos, nya naay 5 ka guarantor, say si A, B, C, D, and E. Upon default ni principal debtor, how much man can the creditor demand from one of the guarantors? Ordinarily, it's only 40,000 pesos. Alright? Kaya ang guarantors will only be liable for their respective share only. It's like a joint obligation, but of course without prejudice to them binding solidarily. We also have the concept of sub-guarantor, okay? Sub-guarantee. Ang scenario ani is that si guarantor na siya'y guarantor, okay? The guarantor of the sub-guarantor, the guarantor of the guarantor is the so-called sub-guarantor, okay? Question, how many times can the sub-guarantor invoke the benefit of excusation? 2 times, okay? Pwede niyang ma-invoke from the principal debtor o niya ngadto sa guarantor as well. Pwede siyang maingon, before you can go to me, you have to go after first the principal debtor, and then you go after the guarantor, and then finally to the sub-guarantor. So, kaduha niyang ma-invoke ang benefit of excusation. Alright? So that would end our discussion on guarantee. Just remember some of the salient features of this particular chapter, okay? Katong atong gisgutan ganiha nga ang guarantee could either be, in its broad sense, could either be personal or real guarantee. When we talk about personal guarantee, katunang personal commitment lang yun sa guarantor niya, and this could either be guarantee proper or suretyship. Guarantee proper is what we are discussing karon nga adlaw. And then when we talk about real guarantee, katuning mga pledge, mortgage, anti-crisis, wherein there's a specific property that will be held answerable in case the principal debtor defaults, okay, or does not fulfill his or her obligation. And then we also talked about the benefit of excusation or exhaustion, the benefit of division, and as well as the concept of sub-guarantee. Alright, I hope you learned something from our discussion today. Thank you very much for listening. Happy Independence Day.